Okay, so my talk today is going to be entitled "What's Law Got to Do with It?" And I think sometimes people, when they're thinking about nutrition, about breastfeeding, and you say, "Oh, I'm a lawyer and I work in the field of infant nutrition or breastfeeding," they say, "What? You know, what the heck? What type of law is that?" But I want to try and show that law and policy, their implementation, the drafting of good national regulations, thorough monitoring and enforcement are really, really important, vital to improving nutritional outcomes in any country. So I'm talking here a little bit about pro-nutrition legislation, and something that we've been speaking about for a few years now, particularly when we were doing work with the Interparliamentary Union on how there needs to be a comprehensive nutrition legal framework in order to ensure good nutritional outcomes. And there is specific legislation in the area of infant and young child feeding. We have some international instruments and guidance, etc., that give us an idea as to what they should be. And when it comes to infant and young child feeding, of course, we're talking about implementation, monitoring, and enforcement of the International Code of Marketing of Breast Milk Substitutes, and of course, all the subsequent resolutions of the World Health Assembly that go hand in hand. We have the guidance on ending inappropriate promotion of foods for infants and young children, very important. It not only in terms of regulating the promotion of complementary foods, but it also has elements that help us protecting good breastfeeding practices. Maternity protection is really important. The regulation of the marketing of harmful foods, again, if we want good nutrition outcomes, we need to make sure that people are not being persuaded and parents are not being persuaded to feed things that are harmful or inappropriate. And of course, regulations to create healthy food environments. So that's just some of the elements that are necessary when we're talking about a legal framework in the context of infant and young child feeding. And of course, optimal breastfeeding, suboptimal breastfeeding is a real problem. Sorry, I skipped too quickly there, but breastfeeding, of course, is really important. And overall, trying to deal with child undernutrition, we know that leads to a vast majority of infant young child deaths, so we really need to deal with this. But I want to make the point that a good nutrition outcome is not the same thing as just having access to good and healthy foods. We can do that all we like, make sure everybody has access to healthy foods in adequate quantities, but that in itself will not lead to good nutrition outcomes, particularly when it comes to infants and young children. It also requires good hospital practices. I know everybody here is aware of how important, for example, the 10 steps are, the Baby Friendly Hospital Initiative, in order to ensure that breastfeeding gets off to a good start, that mothers get the support that they need. It also requires other policies that are going to protect, promote, and support breastfeeding, and it requires good water and sanitation, access to water and sanitation. These are all required for us to have successful nutrition outcomes. But the public also needs protection from the aggressive promotion of unhealthy foods and beverages, and we know that in the last few years, this has become a major problem. We know the aggressive way that sodas, sugary drinks, unhealthy food products, snacks are being promoted aggressively, very often aimed at either directly at children or at parents of children. And in order to do this, in order to have this comprehensive nutrition framework, there are a number of sectors who need to be involved, and it requires an adequate policy and nutrition legislative environment to be created. So just to give you an idea of the scope of the extent of what this legislation policy framework or environment should look like, we need legislation with regard to food safety and food quality. We want the public to feel safe, to feel confident that when you're buying a product, that it is safe, that it's not contaminated, that it's of adequate quality, nutritional quality, etc. Food labeling and food marketing is really really important, and here we're thinking especially when it comes to foods for infants and young children. Labeling is an integral part of the marketing process, if you like. So labels that make claims about the product, that make them look very attractive, that mislead the public, cannot be allowed. And again, when it comes to infant and young children, we know that there should be no promotion of any sort of breast milk substitutes, feeding bottles and teats. And we know that in the case of foods for infants and young children, there should be no inappropriate marketing of those products. And one thing that's really important, I think, in the guidance on ending inappropriate promotion of foods for infants and young children that is often missed, is that where governments don't have adequate standards for complementary foods, and we know there's a big problem of complementary foods out there that are not nutritionally adequate, that have too much sugar, too much fat, too much salt, etc. Where those standards are not in place, then complementary foods should not be promoted either. And there are very few governments that actually have, or countries that have those standards in place. We need legislation on consumer protection. Fiscal measures can also be very important in improving nutrition outcomes in terms of taxation of unhealthy products and subsidies to make healthy things more available, less expensive, etc. We have to look at the nutrition of school-age children, and that includes, for example, making sure that in schools and around schools and childcare centres, they're not being used to promote soft drinks, unhealthy snacks, etc., etc. And making sure that the quality of food that's given to children in schools is appropriate and healthy. Household food security, making sure that families have access to the nutrition that they require, the food and nutrition that they require. Food fortification is very important. It's been a huge help in many countries in dealing with certain micronutrient deficiencies. The fortification of staple foods, for example, important. Breastfeeding, I know I don't need to say much about this to this audience, but policies around breastfeeding are very important. Hospital policies, as I mentioned, social policies to enable women to breastfeed, to create an environment that's empowering to women to breastfeed. And I also mentioned water and sanitation. So I think you can see that law policy has a huge role to play if we want to have good nutrition outcomes. Breastfeeding, we need to protect, promote, and support 6 months exclusive breastfeeding and continued breastfeeding with good complementary feeding for 2 years or beyond. And I just wanted to mention, most of you, I'm sure, will have read this new latest Lancet series, came out earlier this year. 3 excellent papers, but they're highlighting how breastfeeding is so crucially important, but it's increasingly challenged in a market-driven world. How the marketing of commercial milk formula is intended to capture parents, to influence parents, communities, the science. The companies try and influence the science and scientific outcomes of research, and of course they try and influence policy as well. And then a third one on the political economy of infant and young child feeding. These papers are available for free. If you haven't read them, they make good reading, provide us with good arguments for as to why we have to continue with our work in protecting, promoting, and supporting breastfeeding. I mean, just very quickly, we know part of the reason that some of the reason that breastfeeding is so important in today's and for a country like Ireland or in the United Kingdom or the United States. The issue of overweight and obesity is a huge growing problem, and we know that non-breastfed infants are at a higher risk of overweight or obese and type 2 diabetes. So that's a really important aspect. We know that longer breastfeeding is associated with an increase in IQ, and that eventually leads to increased adult earnings. Breastfeeding reduces the mother's risk of certain breast and ovarian cancers. Governments, we know, and I know that Claire is very well spoken around the issues of governments having a responsibility to protect, promote, and support breastfeeding under the Convention on the Rights of the Child or other human rights instruments. So when people say to you, oh, this code, for example, is just a recommendation from the World Health Assembly, no, it is not just a recommendation. It is actually legally binding in terms of governments' human rights obligations, and they are therefore obliged to implement, monitor, and enforce the code. And yet we know that breast milk substitute companies still spend millions, if not billions of dollars to persuade mothers to give up breastfeeding, or to persuade health workers that maybe they should be recommending breast milk substitutes over breastfeeding. And all of this undermines a woman's right to make informed decisions about how she's going to feed her babies. These are some of the sorts of advertisements that we've seen. This, for example, is the SMA trying to provide mothers with information on how to breastfeed after a C-section. We know that companies that manufacture breast milk substitutes have absolutely no interest in getting women to breastfeed successfully, and that's why this sort of thing should not be allowed. We have a lot of advertisements around the world, this is from Canada, of trying to make an equivalence or even make bottle feeding seem better. If you look here, really the mother on the right seems to be making better eye contact and better having a better experience with her bottle feeding than the breastfeeding mother. And again, digital marketing and social media. This is Facebook being used to promote Kendamil milk in Ireland. So these are all violations of the code, and all the sort of things that companies are still up to, and up to even more in social media and digital marketing platforms that we need to do something about. So we know we have this International Code of Marketing of Breast Milk Substitutes that was adopted by the World Health Assembly in 1981. It's not an old document, as some would have us believe, because it has been updated regularly every couple of years by subsequent resolutions of the World Health Assembly. And these subsequent resolutions have the same status as the code itself, so they have to be read together. As I said, it's a global recommendation from the World Health Assembly. All states are urged to incorporate it into national legislation, but we know under the CRC they're actually obliged to incorporate it into national legislation. We know, in fact, the companies themselves and market research organizations like Euromonitor know that the companies feel that regulation is a constraint on their profit-making activities. And we know that the industry is fighting a rearguard action against regulation on a country-by-country basis. All of us that have some input into trying to improve legislation or get countries to adopt legislation, we know that the companies are there to try and prevent that happening, or make sure if legislation goes through that it's as weak as possible. We also have this guidance on ending the inappropriate promotion of foods for infants and young children. Very important as we are trying to help countries adopt legislation now. We want them to incorporate the code, the resolutions, and the provisions of this guidance. It contains some very important aspects that help with breastfeeding as well. For example, it clarifies that breast milk substitutes now means all milk products that are marketed for the use of children up to the age of 36 months. It also has some very good provisions on ending conflict of interest in the healthcare system, basically trying to keep the baby food industry at arm's length from the healthcare system. So it's an important document. Since I don't have time to go into a lot of detail with regard to these instruments, UNICEF developed two guidance documents that I think are very reader-friendly, available for free on at the Global Breastfeeding Collective. That's actually a link down there. If you just Google Global Breastfeeding Collective and go into their toolkit, you will find what I should know about the code, which is a guide to the code. And also another one that's quite important is protecting infant and young child nutrition from industry interference and conflicts of interest. So you might find those of interest to explain in a little more detail what I've had to kind of rush through this morning. We know that if governments insist and create good laws and then monitor and enforce them, companies, even the big companies like Nestle, will comply. This is a recent example from Bangladesh, where their law does not allow for embellishments on labels. So you can see that Nestle had to remove the heart and some of the claims that they had, and which they still have on their lactogen labels around the world. This is the best way to show where laws work, because it's very difficult actually to demonstrate that a law is working because there's no promotion in a country. It's very difficult for me here to give you examples of no promotion, but with labels we can see the changes that are made, and that companies will comply with laws if they are monitored and forced, and of course if they're well drafted in the first place. In terms of code legislation in Ireland, like all of the other EU member states, scores very poorly, 32 out of 100. You can see that from the IFAN WHO UNICEF 2022 status report. You can see the areas where it does very poorly, including promotion in health facilities. So clearly there's a lot needs to be done. I mentioned that maternity protection is very important. We have the ILO Maternity Protection Convention of 2000, which provides for at least 14 weeks maternity leave, and a recommendation, which is not the same as the convention, but it does, it's not as powerful, if you like, as the convention, but it does recommend at least 18 weeks. And of course, when we have maternity leave, the cost shouldn't be borne by the employer, but by national insurance schemes. Ireland, it seems, this is the 2014 ILO report, which is the last one that they did. It shows that Ireland has good, at least on paper. I don't know what it's like in practice. Maybe some of you can testify to that, but it has good maternity leave provisions, provides for in terms of the I see 42 weeks, 26 weeks of which are paid at 80%, and it allows for 60-minute nursing breaks per day. So it does quite well there. I mentioned that overweight and obesity is a huge problem. There's a startling increase in rates of obesity and overweight. And back in 2015, only one country did not, in the world, did not have an increasing prevalence of overweight and obesity. Here's, I mentioned there's this set of recommendations on the marketing of foods and non-alcoholic beverages to children. This is really important. We know the way that children are targeted for sweet snacks, all sorts of things. And there are many marketing tactics, tricks that are used to get kids to buy these products or to nag their parents to buy them these products, including, of course, on social media, games, video games that children have to do, and also the fact that these products are very often put in the supermarket, if you've ever noticed, at a very low level, so kids can actually reach them, even if they're in their pushchair or whatever, as the mother's driving by, they see these things. So this is another really important aspect. And again, I don't have time to go into this in much detail, but again, there are two recent UNICEF publications which help that, which help explain what the problems are and what needs to be done. One is a programming guidance on the prevention of overweight and obesity in children and adolescents. And the second one is on effective regulatory approaches for the prevention of overweight and obesity in children and adolescents. There are 5 of these regulatory aspects with regard to that. One is, of course, the marketing practices. Secondly, the food labeling, and we've seen in some countries where, for example, you have front of package labeling symbols or whatever to let people know, for example, if a product is high in fat or sugar or whatever. Food reformulation, actually having regulations so that the content, the quality, the ingredients in foods is made healthier and less dangerous. Fiscal measures, I mentioned those before. What's sometimes referred to as sin taxes, putting taxes on unhealthy foods or drinks, and incentives to subsidize, for example, healthier products, and the food in schools aspect, which I also mentioned. I'm going to stop there. I'm sorry it was such a rush through it, but I was given 20 minutes, and I hope I've managed to keep to the time, give you an idea of what are, of how important, first of all, law and legislation, monitoring and enforcement is to ensuring that we have good nutrition outcomes, and just an overview on the scope of what needs to be done to do that, with a particular focus on what we need to do to improve infant and young child nutrition. And one last thing I want to say, I didn't put a slide, but I know today we're talking about emergencies. Breastfeeding, having good breastfeeding rates is like one of the best preparatory things you can do to avoid issues when there's an emergency. If most women are breastfeeding and an emergency strikes, then you're going to be in a good situation. And the code applies, I would say, even more in emergencies than in normal life. It's there to not just to protect breastfeeding, but it's there to make sure that when breast milk substitutes are needed and used, that they're used as safely as possible. So I just wanted to throw that in at the end, so that you don't think that I'm completely disregarding the fact that this webinar is dealing with young child feeding in emergencies. Thank you very much, and I'd be happy to take any questions.
Thank you so much, David. Can you hear me okay?
Yes.
Brilliant. Can you see the screen? There's a question on screen for you from Jodine Chase.
One of the recommendations in the report, 10 years of progress in child feeding emergency, is for governments to adopt legislation to prevent BMS donations in emergencies. Yeah, I think you're right, Jodine. It's one of the things that we noticed when we were reviewing the 2022 report for countries in South Asia, that there are limitations to that report. In terms, it tries to look at the main provisions of the code. It tries to look at, it's incorporated some of the provisions on of the guidance on ending inappropriate promotion of foods for infants and young children, but it doesn't ask a question about donations in emergencies. And I don't see why they shouldn't do that, and I think that's something that can be raised with WHO and UNICEF and IPFAN, whoever's there from IPFAN that's having an input into, because I know you're involved in the will be involved in the 2024 report. This could be something I think that that you could ask be added, because I think it is very important. If it's not there in part of the data that we're collecting, then of course it will get ignored. So I don't see why that shouldn't be raised with WHO and UNICEF.
Great, thanks, David. We've one more question there in the chat group from Maurice in IBFAN.
Yeah.
And she's asking about export directives on breast milk substitutes of the EU. Do these impact Irish foreign trade or relief donations?
You know, to be honest, Maurice, this isn't something that I've really looked into, so I'm not going to commit myself to an answer here until I'm not sure if you have. I mean, sometimes I consult you on issues around the EU, as you know, because it's not when I was working for UNICEF, basically concentrating on the least developed middle income countries, I didn't have a lot of experience in working on issues around the EU. I don't know. Do you have any? I mean, presumably you're asking in the question. You don't know, but it's something that we definitely need to look into.
Thanks so much, David. We don't have any more questions in the room, so we would like to extend our sincere thanks to you, and we're really grateful for your input and your expertise. And if you can stay on, that would be great. We'd love you to join us for the rest of the afternoon session.
I'd be happy to. Yeah, I'm looking forward to it.
Brilliant. Thanks so much. So we are going to Dr. Claire Patton now, who is one of the co-PIs on the grant. And I'm going to just stop your sharing, David.
Oh, yes, I'll do it. Yeah, there we go.
Thanks so much. Yeah. Everything's up.
Thank you, Liz. I've come here with no voice and no technical abilities either, so I appreciate your help. So please do excuse my voice. So my name is Claire Patton, and until very recently I was based here in the School of Law at Queen's, but I have now moved to the University of Leeds, so I'm based over there. So while at Queen's, I partnered with Liz and Aileen at TU Dublin to apply for the HEA grant. I did have a bit of a spiel I was going to talk about, but for these reasons and for reasons of time, and because Liz and Aileen have already given such a good background of the grant, I'm just going to skip ahead a little bit. So I am going to talk, so my background is commercial determinants of health. I have a particular interest in the health of women and children, and I research this through a business and human rights frame. And so I like to think of the problems that we have around infant and young child feeding through a human rights frame. So what solutions can we think of through the human rights frame? In other words, whenever, and specifically what I'm looking at for this part of the project is how corporations might influence infant and young child feeding. So in other words, when business profits determine health outcomes, how can international human rights law be used to protect us? So the importance of recognizing breastfeeding within a human rights framework. So breastfeeding is a determinant of health for mothers and babies, and this can be quite a controversial statement, and I'm going to revisit why it can be controversial at the end of my talk. For now, what's on the screen is a very brief overview of the health benefits of human milk, because I'm a doctor of law, not a doctor of science or nutrition, but those who do specialise in such research have provided us, because they have studied and they are studying research that provides us with the empirical evidence of the importance of human milk to the morbidity and mortality of infants and young children. And if I direct you to the quote that is on the bottom of this page, I think that it really sums up the approach that we need to have to protect infant and young child feeding. And it says that the decision whether to breastfeed shapes health, education, social protection, child protection, trade and commerce portfolios, and as such is everybody's responsibility. So the commercial milk formula industry as a commercial determinant of health. So large corporations not only wield enormous economic power, but they also build huge social and political power. So this provides the largest multinational corporations with the tool to shape the health of individuals and populations in ways that map onto the goals of the business plans and the shareholder interests. And that is what we mean by commercial determinants of health. So there are various understandings of commercial determinants of health, but in the context of my work, I like to use the one that is on the screen. I think it is the most appropriate. The strategies and approaches used by the private sector to promote products and choices that are detrimental to health. So keeping that in mind, I want to think about the ecosystem of infant and young child feeding in Ireland. So I'm just going to put some facts up on the screen. So there are 6 commercial milk formula companies, 6 commercial milk formula producers. So that's CMF, which I refer to throughout the presentation. CMF is commercial milk formulas. And there are 6 who dominate the market globally. That is Abbott, Danone, Feiha, Friesland, Nestle, and Reckitt. Out of these, Danone and Nestle, via its subsidiary, and Abbott all have manufacturing facilities in Ireland, as well as 3 other CMF producers. And these all source their milk supplies from the Irish dairy processors. Another fact is that the Irish infant formula market has been described by the Irish Agricultural and Food Development Authority, which is a semi-state authority, as lucrative for Irish milk producers. Annual exports are over €1 billion for the 6 global infant formula companies based in Ireland. Another fact is that Enterprise Ireland is a state agency, and it's responsible for the development of manufacturing and internationally traded service companies. And through Enterprise Ireland, the Irish taxpayer directly subsidises CMF companies in Ireland. And so the final fact, which I don't think anybody in this room doesn't know it already, but it is that Ireland has the lowest breastfeeding rates in Europe and sits among the lowest breastfeeding rates in the world. So these are all facts. So let's have a case study, a commercial determinants of health case study, to really understand what we mean whenever we talk about this definition. So the OSMR, which some of you might be familiar with, I know Aisling down at the back of the room will be very familiar with it. Aisling is a colleague of mine working on the OSMR bill, and we're part of a group that have been researching and trying to get some amendments into the bill over the course of the last 18 months, maybe longer, Aisling. So the Online Safety and Media Regulation Bill was signed into Irish law in December of 2022, and the Act transposes the EU Audiovisual Media Services Directive into Irish law. It establishes a regulatory framework for online safety, and it updates the regulation of television broadcasting and video on-demand services. So as part of this, an Online Safety Commissioner will oversee the regulatory framework for online safety, and they will have the power to make binding online safety codes. The codes will ensure that online service providers address the availability of content that is harmful. So before this Act was passed into law, it obviously goes through various stages of amendment. And one amendment was the inclusion of the following. So you can see that it's highlighted in green, where within that provision, it says provision made for the purpose referred to in subsection may prohibit or restrict in accordance with the law the inclusion in programmes of commercial communications relating to food or beverages considered by the Commission to be the subject of public concern in respect of the general public health interests of children. And this was what we wanted put in particular infant formula, follow-on formulas, and then it goes on to say, or those foods or beverages which contain fat, trans fats, acids, salts, or sugars. So if this inclusion was allowed to stay, it would mean that the new Media Commission would have the power to prohibit advertising relating to follow-on milk and to infant formula milk and follow-on milk. And so what happened next is a perfect insight into the practical application of that definition of commercial determinants of health. So remember that. The strategies and approaches used by the private sector to promote products and choices that are detrimental to health. So through freedom of information request, what is up on the screen is a letter that was sent to you. Now, I don't want to move about too much because of the online audience, but I want to, so I can do it here. So this letter was sent by somebody called Conor Mulvihill. So you can see that he is representing the Dairy Industry Ireland. So Dairy Industry Ireland is a trade association representing Irish primary and secondary dairy producers, including the infant formula sector, and is an affiliate member of IBEC. So you can see IBEC are here. IBEC is Ireland's largest lobby and business representative group and has 6 regional offices and a Brussels office and an extensive international network in the US and the UK. So what is it that got Dairy Industry Ireland and IBEC worked up? So they wrote to Minister Martin. So it was Catherine Martin was the minister whose office was responsible for overseeing the publication of this bill. So in December, when this had been signed into law, he wrote, I write to you on behalf of the Dairy Industry Ireland Specialised Nutrition Company members. Specialised nutrition includes infant formula. In relation to the recent signing into law of the Online Safety and Media Regulation Bill 2022. And it didn't take them long. Remember, this was only signed in December, and we see this email is dated December. As a sector, we have from the outset voiced our support for the protection of children from harmful online content. And the next two words are very interesting: through codes and policy. So what does that mean? That means self-regulation. So they're very determined to keep hold of self-regulation. They don't want mandatory regulation through law. As you know, however, we are, however, very disappointed in and fundamentally disagree with reference to communications on infant and follow-on formula as a subject of public concern in primary legislation. So they don't want this in primary legislation, which has the potential to undermine trust and disregards the role of these products. Formula milks are recognised as the only legitimate, safe and nutritionally complete alternative for infants when breastfeeding is neither possible nor chosen by the parent or caregiver. Now, of course, we don't have the time to unpack this word by word, but there is nothing within the Act that seeks to undermine trust in these products. So they go on to say that during the course of the discussions with your officials in the department and as part of the legislative development process, which I'll get back to in a second, we have requested amendments in the text of the legislation to not only ensure that trust in these products continues, but also to accurately reflect the current stringent EU regulatory framework that already governs communications in relation to formula milk. We are again disappointed that these requests were not accepted. So with commercial determinants of health, it's where companies feel that they are in a position of power and influence to the degree that they feel that they are entitled to shape policy and to shape law and legislation. And you can see the disappointment and the anger coming through, that it's how dare you not take our suggestions on board? How dare you go against what it is that we were advising? As focus now turns to the establishment of Commission Naman and future discussions on the building of the overarching new framework, we ask that you fulfil your already stated commitment to ensuring that the new body will consult in full with all relevant stakeholders. To that end, any discussion in relation to infant and follow-on formula must also involve direct engagement with the industry, and our members look forward to engaging constructively and collaboratively in that regard. So in that last paragraph, they are going directly against the code, and they are calling themselves stakeholders in this situation. Now, within my work, I argue that the formula industry and associated industries such as the dairy industry have no seat at the table whenever it comes to infant and young child regulation, because they are profiting from infant and young child feeding. And so they shouldn't have a say in how infant and young child feeding is regulated. And this just because it made me laugh. Whenever you're putting a slideshow together, you're looking for visuals that will grab attention. And so I just went on and thought, right, who are the members? And they so neatly and colourfully had this. So all I had to do was a screenshot and put it up. So who the members are, well, we have Abbott here. You remember we were talking about the biggest formula producers in the world. So here we have Abbott, here we have Nestle, and we have Danone hiding in there somewhere as well. Danone, thank you. So, and then of course, Wyeth, our subsidiary of Nestle. So 3 out of the 6 most powerful CMF companies in the world are lobbying the Irish government against the regulation in the OSMR bill. So I want to talk just quickly now about breastfeeding within international human rights law. So I want to highlight that there are certain breastfeeding rights recognised in international human rights law. Again, I think it's something that's widely known with this particular audience that the Convention on the Rights of the Child at Article 24E states that, says that states are expected to ensure that society has access to education on the advantages of breastfeeding. And then in General Recommendation 34 of CEDAW, which is the Women's Rights Treaty, states must ensure that rural women have access to information on breastfeeding. So this is the current landscape, but it could be made much, much stronger. And there are serious flaws and weaknesses with it as it stands at the moment. Of course, there's also the International Code of Marketing of Breast Milk Substitutes. Again, something that's very, very familiar. And I think that we have some delegates who are online who were, involved in this for decades, the original kind of contributors to this. But just very briefly, for those of you who might not be as sure, the International Code of Breast Milk, Marketing of Breast Milk Substitutes was enacted or was adopted rather in 1981. And of course, there are subsequent resolutions. So it sets the global standards for the marketing of CMF products. And it's what we would call soft, but highly influential law. So it's not binding, but countries are expected to fulfill their obligations under it. The objective of the code, and I think that it's always very important to remind people of this, is not to prohibit access to commercial milk formulas, but to ensure the safe feeding of all infants and young children. I'm not going to go through this slide in detail. It's just to show some of the landmark papers, the landmark milestones rather, in the development of advancing the protection of human rights, of breastfeeding rather, within a human rights framework. So with my own article that's forthcoming as part of this project, where I examined breastfeeding in a human rights context, I argue that breastfeeding should be recognised using the same roots to recognising other contemporary rights, such as the right to water, the right to a clean environment. So these are things that are said to be implicit in our foundational human rights treaties, but they wouldn't have been recognised as so important whenever those foundational treaties were first drafted back in the 1960s. So state responsibilities, and I think that it's really important to start this particular slide off with a reminder that there is not a human right to breastfeed. I see this very often said, oh, there's a human right to breastfeed. There is not a human right to breastfeed. There is an obligation on states to provide education on the benefits of breastfeeding, but there is not a human right to breastfeed. And that's why situating breastfeeding and infant and young child feeding more generally within the business or within the human rights narrative is so important, because there is a lot of work to be done here. Human rights laws such as Article 24E of the CRC does not apply directly to CMF companies. International law only applies to states. As such, states have a legal duty under the Convention to ensure that the education on the benefits of breastfeeding is provided to all in society. But CMF companies do not hold such a duty, and it's important to remember this. And the reason it's important to remember that CMF companies do not hold an obligation under any kind of international law to protect breastfeeding is because on their websites, there is often, for example, Nestle or Danone will say that they protect breastfeeding, or they promote breastfeeding, or they abide by the code and things like this. There is no obligation on a CMF company to promote or to protect breastfeeding. And Samantha is going to talk about this a little more in her talk. But what the CMF companies have is what we would call a negative responsibility, and that's simply not to market. We don't need them to come into the space of promoting breastfeeding or anything else like that. We just need them to back out of the space altogether and just not market their products. So more broadly, states hold a duty to protect citizens from the actions of non-state actors in interfering with all of the other rights, such as the right to food, the right to health, the right to privacy, the right to autonomy. But again, no such duty falls on CMF companies. Then states are also expected to fulfill their duties under the International Code of Marketing of Breast Milk Substitutes to protect citizens from CMF marketing. So what about CMF businesses? The CMF industry largely maintains that as private actors, they do not hold any responsibilities regarding marketing beyond what is codified in local laws. However, the code does speak directly to CMF businesses, as you can see on your screen there. at Article 11.3, where it says that independently of any other measures taken for implementation of the code, manufacturers and distributors of products within the scope of the code should regard themselves as responsible. So what does all of this mean in the context of breastfeeding, CMF marketing, and human rights? Well, a particular business and human rights tool can help us to better understand the responsibilities of the CMF industry in the context of human rights. The UNGPs, the United Nations Guiding Principles, establish the standards expected of business regarding their human rights responsibilities. These are a form of soft law. This means that the UNGPs are highly influential in setting the standards expected of businesses in the context of human rights. The UNGPs have informed domestic law, regional law, and international law on business and human rights, and they have been cited in court cases. Under the UNGPs, businesses have some responsibilities that are of interest to furthering the implementation of the code. I'm going to focus on Principle 11 of the UNGPs. So the commentary for Principle 11 of the UNGPs clarifies that the responsibility to respect human rights, so this is for businesses, the responsibility to respect human rights exists everywhere in the world, regardless of borders or local laws, over and above compliance with national laws and regulations protecting human rights. Therefore, applying different marketing standards, so for example, identifying high and low risk countries or changing marketing strategies according to local laws, runs counter to the UNGPs. Principle 11 states that companies may undertake other commitments or activities to support and promote human rights, which may contribute to the enjoyment of rights, but this does not offset a failure to respect human rights throughout their operations. So therefore, a commitment to address, for example, child labour in the supply chain or environmental harms does not annul responsibility for companies regarding their marketing of CMF products. And businesses are also reminded that they should not undermine states' abilities to meet their own human rights obligations. And as we saw from the slide a few slides ago, where these businesses were directly interfering with the legislative process in the Republic of Ireland. So a failure of code implementation as viewed through the UNGPs. By placing the issue of code implementation within a rights-based framework, specifically the UNGPs, we can see a contagion effect emerge that begins with one act of non-compliance within the code. So this is a simplified version of this effect. We can imagine a company failing to adhere to Resolution 69.9, which is essentially not marketing any CMF aimed at infants and young children up to the age of 36 months. And I've used this because none of the big six companies adhere to Resolution 69.9. So this then means that the company is not meeting its responsibilities under Pillar 2 of the UNGPs. So now it is interfering with the human rights of mothers and children. And we know that under international human rights law, clarified under Pillar 1 of the UNGPs, that the state has a responsibility to protect citizens from non-state actors from interfering with our rights. So this would obviously be more detailed, and we could include the actual rights or insert links detailing specific harms, but this is just to illustrate the concept. So I want to finish my talk by leaving no doubt whatsoever that the CMF industry is very, very aware of their human rights responsibilities, and that the leading CMF businesses have web pages that are absolutely filled with dense stories of how they can make the world a better place by working on addressing their carbon emissions or improving their supply chains to ensure that forced labour is not part of their business. But following an intensive study of these websites, it shows that on none of the leading CMF companies, so that is the 6 leading, globally leading CMF companies, There is recognition of CMF marketing as a human rights issue, and we know that that runs counter to the standards set out in the UNGPs. Good actions in one part of the company do not offset bad actions in another part of the company. Human rights do not work like that. So why is breastfeeding so controversial? Why is infant and young child feeding so controversial? For-profit companies have commercialized the act of infant and young child feeding. It is in their best interests to feed the narrative of the so-called mommy wars between those who breastfeed and those who do not. So the only way that we can move away from that narrative is by listening to the lived experiences of mothers and parents and removing for-profits from any part of the decision-making process on law and policy around infant and young child feeding on the island of Ireland. Self-regulation does not work. We know that the reason that the industry does not want hard law regulation on the marketing of CMF products is because for over 40 years, they have used the self-regulatory approach to create loopholes to circumvent the provisions of the code. And on loopholes, such as cross-promotion, I will now hand over to my colleague at Queen's, Dr. Samantha Hopkins, to discuss her preliminary findings on mapping the legislation relating to commercial milk formulas in Ireland. Thank you.
Just to make sure, can everybody online see that okay? Because I didn't realize there was a pop-up there. Okay. So good afternoon. My name is Samantha Hopkins. I'm the research fellow on the project. So I am based at Queen's University Belfast, and my background is in business and human rights. So I have been taking a look at the regulation on commercial milk formula, CMF, on the island of Ireland, so both in the north and in the south. And I've essentially been doing a doctrinal legal review of the relevant law that's in the area over the last while. And this is with the eventual goal of determining how these laws then map onto cases of emergency where those happen. So this is the baseline essentially that we're then going to be working on the rest of the project to determine how we can use this regulation in emergency contexts. I can't get to the next slide. There we go. We're good. Sorry. So as Claire has mentioned, there is a state responsibility to protect human rights, coupled with a company responsibility to respect human rights. And the way, as Claire has mentioned, these are slightly different, is that the state responsibility to protect is a positive right. They're required to do something. They're required to implement legislation, and they are then required to enforce that legislation. Whereas the company responsibility to respect is a negative right. So it's the responsibility to not do something. It's the responsibility to not advertise unnecessarily, i.e. at all, for example. So in the domestic context, legislation is very limited, both in the north and the south. Implementing international law on infant and young child feeding is something that is dispersed throughout a wide variety of regulations, but isn't particularly well integrated. So I will discuss that as I'm going through. Aggressive marketing of CMF to families and to healthcare professionals limits the ability of families to make an informed choice regarding how they feed their children. And this should be based on equal apportionment of information and education, both to the families themselves and to healthcare professionals who are involved with those families as well. Where families are bombarded with CMF advertising online and offline, quite often online, anywhere they go, mostly only access to breastfeeding information and information on supposedly the other side tends to be in a healthcare specific setting. So it means that there is a serious imbalance here regarding the information and the education that families are able to receive. And this aggressive marketing then also doesn't help the state of affairs where in Northern Ireland, the median duration of breastfeeding in 2016 was 5 days. In Ireland, about 6% of babies are exclusively breastfed for 6 months. So these are the sort of issues that it's leading to. The key questions that I'm asking in this presentation are, first of all, in a non-emergency situation, how are CMF companies regulated? So what is the baseline, essentially? And where are the gaps in legislation which constrains CMF companies, which allows them to act as they do with such impunity with, for example, aggressive marketing? And where I'm going to go with the rest of this presentation is first, I'm going to look at the opacity and the piecemeal nature of the regulation. I'm going to look at the unnecessary divisions that have been created between infant and follow-on CMF. And I'm going to consider regulation on misleading advertising before then looking at where we're going forwards with this aspect of the project. So first of all, this lovely slide with a lot of regulation on it is intended to show the variety of different laws which enact one suite of infant and young child feeding regulation. So all of this law relates to the first top left box, which is Regulation 609/2013 on food intended for infants and young children, food for special medical purposes, and total diet replacement for weight control. The second column is the implementing legislation in the Republic. The third column is the implementing legislation in the North. The second two rows are the subsidiary regulations. So it's all part of one family, essentially one suite. And this just essentially shows how opaque and how diverse this regulation is in this one small section. This is not all the regulation by any means, as I'm sure everyone here is aware, that governs infant and young child feeding. There are a lot of other aspects here. And so this is simply one small part of it. And this is the kind of opacity that families and the healthcare professionals are up against whenever they're trying to then understand where companies are coming from whenever they're selling this formula. And specifically, this is a state of affairs which plays into CMF companies' hands. They have large legal departments which are better able to navigate the wide variety of laws that you see here and beyond this as well, so regarding trade and other aspects. And there's also on the other side extremely lax enforcement from the state side, which means that it's almost a double whammy where you're getting the worst of both worlds, essentially. So the second point that I'd like to discuss is this arbitrary distinction between infant formula and follow-on formula. And the first, arguably most important one, and I will hide this at the bottom as I think this may cause a problem, is that the labeling, presentation, and advertising of infant formula must avoid pictures of infants or other pictures or text which can idealize the use of such formula. In the follow-on context, only labeling must avoid pictures of infants or other pictures or text which can idealize the use of such formula, which means that for follow-on formula, you can both present and advertise formula in a way that uses pictures and idealizes the use of the formula, which then is this sort of idea of this passive advertising, which Claire had mentioned previously. This is often described as a loophole in the law. It doesn't require any particular amount of lateral thinking that one would really require from a loophole. Generally, though, there was a decision made at the EU level to exclude follow-on formula from the infant formula regulation, essentially. They made the decision that follow-on formula can be sold and presented and advertised using pictures and text which can idealize and pictures of infants. The fact that many brands then also have these families of formula where they all look very, very similar. The follow-on is very similar in packaging to the infant formula, and I've got a slide next that shows this. Again, I'm sure people are aware of this. It means that marketing of the infant formula occurs in passing, even if not directly, which is a complete failure to follow International Code of Marketing of Breast Milk Substitute standards, that there should be no advertising at all or other form of promotion of CMF to the general public. So this is both at an EU ROI NI level, not an international one. The distinction here as well between infant formula and follow-on formula is indicative of this light touch approach to the international law. They're taking a letter of the law approach or a letter of the code approach, essentially, and it's been adopted both by the EU, ROI, and NI. Neither the ROI nor NI have developed the law further than this. And this is despite both the fact that it is expected that within EU rules, member states can and should go further than these rules and develop the law themselves. And also specifically in the context of infant and young child feeding, Article 8 of the 2013 Act says that member states may further restrict or prohibit such advertising themselves. So there is actually written in law that they can go further than this, and they simply aren't. And this could be due in all three cases, both to a lack of understanding of the issues which are present in the area of CMF and CMF marketing, and perhaps more cynically due to a desire not to hamstring a lucrative domestic industry as well. So the other points which I have here on this slide, you can see they all apply to infant formula and not to follow-on formula. For infant formula, labeling must include a statement on the superiority of breastfeeding. This is not required for follow-on formula. Labeling of infant formula may bear nutrition and health claims only in certain cases. Again, this does not apply to follow-on formula. Any infant formula being placed on the market has to go through notification to the state. For follow-on formula, it's only where the formula uses ingredients that are outside the ingredients which are set out in the regulation itself. So the distinction there is that any infant formula is considered important enough to be notified of, whereas follow-on formula is not. There are also limitations on advertisement of infant formula to only be included in scientific publications and include scientific content. This, again, is not applicable to follow-on formula. So it can be advertised much more broadly, as we do see. There's prohibition of point-of-sale advertising, use of samples, and giving of coupons directly to the consumer only for infant formula. Again, this is allowable for follow-on formula. And labeling must avoid, prohibition of provision of pre or low price products, samples, or other promotional gifts to the general public or pregnant women, mothers, or members of their families. And this can be either directly or indirectly via, for example, the healthcare system, which is why it's so important that the healthcare system and health workers are aware of this. So all of this does then present quite a significant gap across the island. All of these requirements, which were mentioned on the previous slide, would be equally as useful and equally applicable in protecting infants and ensuring parents make the best decisions if they were to apply to both infant and follow-on CMF, as the result is the same. The division between infant and follow-on formula is also then evidenced quite obviously in the definitions. So the definition of infant formula is food intended for use by infants during the first months of life and satisfying by itself the nutritional requirements of such infants prior to the introduction of complementary feeding, while follow-on formula is defined as post-complementary feeding formula, where it's the principal liquid element in a progressively diversified diet. And this does rather belie the assumption or the argument that formula is intended as a supplement to breastfeeding. The use of statements by itself or principal liquid element does show that formula is intended to stand alone, which does make sense in contexts where someone needs to feed a child in this way, but it is very much written into EU law that this is the definition of formula, and it does rather belie that argument that it can stand alongside breastfeeding. On the right here, I've put some images of certain brands of formula, families, so-called, that all look essentially exactly the same. On the left, every single time you can see the one which is the infant formula. The other ones are all follow-on formulas, and they all look in each group exactly the same. They're identical. If you start trying to advertise something that has a 2 or a 3 written on it, you're going to be, for all intents and purposes, advertising something with the 1 written on it as well. Even though technically it's not legal, they are complying with the letter of the law rather than the spirit of it. And as Claire has mentioned, we are seeing slowly changing trends now with the ROI Online Safety and Media Regulation Act 2022, which does now bring in a slight change, which hopefully going forwards can be both embedded better in ROI law and brought into NI law, as well as internationally as well, because this is something very new that we're seeing in the online context as well. And the third point that I'd like to look at is this idea of misleading advertising, whether something is misleading or whether it's considered material information. So first of all, Regulation 1924-2006 looks at nutrition and health claims. There is a requirement for consistency with generally accepted nutrition and health principles. And this paves the way for exploitation of the system by an industry which has a monopoly in the area, such as the CMF industry. Despite the fact that health claims are assessed by the European Food Safety Authority, the FSA, lobbying by business can have significant reach throughout adjacent fields, such as healthcare. So it does extend further than this. Despite the prohibition of gifts or promotion to healthcare professionals, CMF companies with their marketing experience as well as their legal experience can circumnavigate these restrictions. And they can do this through, for example, sponsored study events for healthcare professionals. Directive 2006-114 concerns misleading and comparative advertising, and it provides that comparative advertising can be legitimate, where it's not misleading and compares material, relevant, verifiable, and representative features. Member states are required to implement enforcement measures which are accessible by those with a legitimate interest. And from this phrase, you can see with a legitimate interest, it is entirely dependent on the definition of legitimate that's used, what is considered legitimate. As Claire was mentioning earlier, you can see that the infant formula companies do believe that they themselves would be a legitimate interest. Perhaps NGOs would be a legitimate interest. And then, of course, you run up against the issue of funding if NGOs don't have, or voluntary organizations don't have the funding to actually be able to take these cases. And thirdly, there's the ROI Consumer Protection Act 2007, and this prohibits aggressive commercial practice. And it's notable that the requirement is that such actions cause a consumer to make a transactional decision that the average consumer would not otherwise make. And this, therefore, almost implicitly condones the actions of industries which are inherently coercive or manipulative, such as the CMF industry. It's also important for the reference to the average consumer, which means that ingrained, as I say, endemic or misleading manipulative marketing will not be caught by this regulation, since the average consumer has already accepted that marketing as fact. It's simply part of life. Although such marketing is considered in its context and circumstances, so all is not lost, there haven't been any claims related to the infant and young child feeding industry on the island of Ireland to date. So the code does obviously go a lot further than the law, and I haven't covered all the law here by any means. It's considered best practice, but it's not hard law. So it is used as best practice in, for example, the healthcare sector, but it's not considered to be, well, it is not, in fact, enforceable in any way, really, other than what's in specific legal regulations, which is quite limited. So going forwards then, what we want to look at is how the gaps in CMF regulation can be filled, of which there are a fair few. First of all, we can do this by streamlining legislation in the area. There has been an attempt at streamlining legislation, but this really hasn't gone far enough yet. It is still very opaque and difficult to navigate. There also ought to be a double-pronged approach, so greater state intervention in businesses' ability to operate with impunity, combined with improved education and dissemination of information regarding breastfeeding. So it needs, again, to be double-pronged. States should be limiting the current freedom of CMF companies, but also removing restrictions on access to breastfeeding. So it's coming back to this positive negative responsibility. And third, we really need improved enforcement in practice, as this is almost non-existent. And going forwards, ideally, we would be introducing into emergency planning regulation of essential businesses, because for all intents and purposes, the CMF industry is now essential. Women do need to be given that choice, whether they want one or the other, and it needs to be an equal choice. So you need this division of education with regulation as well on the other side. So ensuring that that's included in emergency planning is very important. Thank you very much for listening, and I will pass back to Claire.
Okay, so this is the last presentation of the day. I just wanted to talk quickly about the next steps that we're doing on our side of the project. So on our side of the project, the other work package that we're looking at is potential emergencies on the island of Ireland. And this it's growing into be an absolutely fascinating research area. Whenever Liz and Daleen first contacted me about offering me the opportunity to come on board as part of this project, I had no idea how much, well, first of all, that it was going to consume my life, but also how relevant and how topical it was going to be. And I said that it's like one of those things, you know, you never see a green car until you buy a green car, and then there are green cars everywhere. But it really does seem to be the case that this is something that is happening more frequently and closer to our shores. Have I done something wrong? Oh, it's not on, sorry, yeah. Thank you. There aren't very many slides on this anyway, thanks Liz. So this is, as I say, looking forward to the types of emergencies that the team at QUB, obviously with myself now based at Leeds, are going to be leading on, looking at the kind of emergencies that we need to prepare for on the island. And we're going to do this through a case study approach. So we're going to try to learn from past emergencies to prepare for future emergencies. And whenever we first put this proposal together, we had a list of what we thought would be the most likely emergencies that could impact in different ways the island. So obviously Brexit, we're looking at political potential emergencies. So Brexit, case study, the Russian invasion of Ukraine. We could look at a pandemic, an epidemic using COVID. Climate is going to feature quite strongly in it as well. And this will involve looking at it from different perspectives, because we look at the CMF industry as a contributor to climate change, but then we also look at the effects of climate change on the island to do with increased flooding, water shortages, hose pipe bans, broken pipes, things like that. But then the third kind of prong to this, if you like, is if we have climate refugees. And I think actually, Helen, it was with yourself whenever you and I had a phone call and we were talking about how if you had, you know, wildfires, and so I was talking about, you know, the wildfires in Greece or what have you, and Helen was saying, well, in the UK you could have a wildfire, say in France or somewhere, and that can sweep up in, so we can be closer to these disasters than what we might even think. Then we're also the other, another case study that we're going to look at is the CMF industry supply chain. So the supply chain is going to be the overarching study anyway. We're going to look how each of these might impact the supply chain, but specifically we're going to look at the US formula shortage as an example of what went wrong there and what lessons can be learned. And then obviously look at localized potential emergencies such as fire and flooding. Now, as I say, it became obvious as we were working through this, things became more obvious to us the more we learned. But one of the, oh, actually, sorry, yeah, I'm just going to skip through that. This is just kind of talking about the infant and young child feeding supply chain, about how each potential crisis could weaken the supply chain and what we need. But I think that this is stuff that, these are issues that have been covered several times by now, so I'm not going to keep anybody here talking about that. This is a slide that I actually wanted to get to because I pop David down there. So the cost of living crisis, whenever we put in the initial HEA funding application, the cost of living crisis did not feature on our submission because it wasn't something that we had thought of at that time as an emergency in the context of infant and young child feeding. But over the last number of months, this has emerged as actually one of the most pressing emergencies that we have. And so it's now come out as one of the front runners of an emergency. It will form its own case study, and we will be looking into the cost of living as an emergency in and of itself. These are just some figures. This is not from my own data. These are just figures that I put together for this presentation today. And again, I don't think that it will come as a surprise to anybody in this room or online that the scale and the number of children that we have living in poverty on this island. And we know that how they are fed impacts hugely on very, very many areas of their lives. I want to talk very briefly. I think that this was, yes, I just want to talk very briefly, going back to something that Samantha had picked up and that I had talked a little bit about earlier, and it ties into the emergencies because of the influence that commercial milk formula companies have in Irish society. And so a key point that I wanted to highlight, because this seems to sometimes skip by whenever people are thinking and talking about formula feeding, is that the key or the objective, the main objective of marketing is to increase sales. And if marketing didn't work, then the companies would not spend billions of US dollars annually on advertising. So consider, for example, that Nestle alone spent approximately $9.9 billion on consumer-facing advertising in 2016 for all of its products. And in their 2020 article, considering the rise in CMF consumption, Baker and others made a, quote, conservative estimate of the global marketing spend of CMF companies to be somewhere between 1.68 and 5.56 billion in 2019. So it's fair, therefore, to determine that the CMF industry spends vast amount of money to persuade women to choose their product over and above any competing milk product, including human milk. And the magnitude of budget assigned to marketing means that it's also fair to determine that the CMF industry deems marketing to be highly successful in its objective to persuade mothers to choose a specific brand of CMF over all other milk products, including human milk. And I wanted to finish up. I'll skip that. Yeah, again, it's just a little bit more about things that have already been covered today. I wanted to revisit that because whenever we are talking, obviously as a lawyer, it's the law that I'm coming from that perspective whenever I'm thinking of solutions. And I want to be very, very clear that the government in both jurisdictions do not have their hands tied whenever it comes to legislating for CMF formula on the island. There seems to be a narrative that in the Republic of Ireland, that because it's an EU member state, that it has to stick very strictly with EU law, and you know that it's up to 6 months and things like that. So whenever we're talking about solutions and moving forward, and we talk about who has a seat at the table and who doesn't, I also think that we need transparency and honesty. And Samantha touched on this in her presentation. And we need people to come to the table and explain why they're not legislating CMF products. They have absolutely got the authority to legislate CMF products. And in fact, under international human rights law, under the Convention of the Rights of the Child, they should be considering the best interests of the child every time a piece of legislation is going through for consideration. So these are just some things that over the last few days, and obviously before that, whenever we've been talking about moving forward, from the legislative point of view that I thought that it was important to be very clear about whenever we had the opportunity for discussions today. So now we're going to have a Q&A. I think with time, we were going to have a Q&A just with myself and Samantha for 10 minutes first, and then we're going to, the four of us, have a Q&A then after, if that's okay, Samantha. Thank you.
Hi, I'm Helen Gray. I'm the coordinator of the WBTI project in the UK. And I'm also represent the baby feeding law group of the UK on the infant feeding and emergencies core group, Mortality League and IBCLC. And first of all, wow, that was an amazing overview of the law. My head is spinning. Thank you for your detailed investigation. And I wanted to bring to your attention an excellent report by the Baby Feeding Law Group UK on the foods for special medical purposes, which also escape most of those restrictions. And that's a really useful report and even an infographic, and could be used to circulate to legislators and policymakers, because it's also an excellent example of exactly what you were talking about. Thanks.
Thank you, Helen.
I was just wondering, do we know if Catherine Martin has responded to that letter?
She has, and I'll get it and I'll put it up on the screen before we go. And she did a great job.
Can I ask, it's probably a two-pronged question. Which government department is primarily responsible for the legislative instruments? And if that's not a single government department, who within government is meant to coordinate the delivery of this legislation?
So this is the problem that we had whenever we were dealing with the OS More bill, because it was the Catherine Martin's department who was looking after that particular, because it was media communications. But then it's the Food Standards Authority Ireland who are tasked with the enforcement of monitoring this in the Republic of Ireland. And then we get knocked about then to the Department of Health whenever it's discussions around this, around infant and young child feeding. So whenever you're looking at an issue which would be of particular interest to us, which is the commercial determinants of health, and we're looking at how corporations are actually influencing feeding decisions,